I want to start with the silence. Not the silence before she said it. Not the silence after the judge spoke. I want to start with the silence that happened in between those two things. The 3 seconds between my wife calling me a worthless nobody in open court, and the judge slowly removing his glasses and asking her attorney a question that changed the entire direction of the morning. 3 seconds. I have thought about those 3 seconds more times than I can count. Because in those 3 seconds I did not move. I did not speak. I did not look at my wife, or at her attorney, or at the gallery behind me, where I knew people were sitting. I looked at the judge, and the judge looked at me, and something passed between us in that look that I cannot fully describe except to say that it was the look of one man recognizing another. Not as a celebrity, not as a name, as someone who had done something real in the world, and been recognized for it by someone who understood what that recognition meant. 3 seconds. Then the judge put his glasses on the bench and said, "Counsel, do you know who this man is?" And the attorney opened his laptop, and his hands started shaking. Welcome to Dad's Retribution. Get comfortable. Because this story starts in a courtroom, and it ends in a courtroom, and everything in between is the story of a man who spent 22 years building something extraordinary, while being told by the person closest to him that he was ordinary, that he was less, that he was, in her exact words on the worst morning of their marriage, a worthless nobody who would never amount to anything. She said that in front of a judge. She should have done her research first. Subscribe right now if you are new here, and hit that bell. Because what was on that attorney's laptop, and what the judge said next, is the kind of thing that does not happen by accident. It happens when a man spends 22 years being underestimated, and finally stops letting it go uncorrected. Stay with me. My name is Arthur Pendleton. I am 64 years old. I live in a house I built on 12 acres, outside of a mid-sized city, that I will not name, because the divorce proceedings are still partially active, and my attorney has asked me to be careful about specifics. What I will tell you is this. I am a materials scientist. I have a doctorate from a university that you would recognize, and I have spent 38 years in applied research. I hold, as of the morning I am telling you about, 41 patents, not applications, granted patents. 41 pieces of intellectual property, registered with the United States Patent and Trademark Office, each one representing a specific solution to a specific materials problem in fields ranging from aerospace composites to biomedical device coatings to next-generation battery technology. I tell you this not to impress you. I tell you this because my wife told a federal judge that I was a worthless nobody who had never amounted to anything, and I want you to understand the full dimensions of what she said. She knew about the patents. She had been in the room for the first one 22 years ago, when I came home at 11 at night and told her the application had been granted, and she had looked up from her book and said, "Does that mean you'll be home at a normal time now?" She knew about all 41. Let me tell you about Marguerite. Marguerite Elaine Pendleton, born Fossey in 1963, was the most compelling person I had ever seen when I met her at a university reception in 1998. I was 37 years old and had spent the previous 15 years in laboratories. I was good at science. I was not good at people in the way that social occasions require. Marguerite was good at people the way I was good at science. She walked into a room and the room reorganized around her. I was, to use the technical term, completely unprepared for her. We were married 14 months later. She was a marketing director for a regional luxury hotel chain, organized, strategic, successful. She understood the relationship between presentation and perception in a way I found genuinely impressive. The trouble began when I started to become successful in my own way, not visibly, in the slow, patient way of someone whose work takes years to move from concept to recognition. The first patent in 2001 was in aerospace composites. The licensing income was modest. She said, "So someone is going to pay you to use your idea?" I said, "Yes." She said, "How much?" I told her. She said, "That's it?" That was 2001. By 2008, I had 11 patents and a research chair. To Marguerite, What I did remained invisible. I was in the basement. She was the engine of the life we lived publicly. I was, in her telling, the background. She was not wrong that I was hard to explain at dinner parties. She was not wrong that she carried more of the social weight. She was wrong about what the work was worth. By 2015, I had 23 patents. 3 of them had been licensed at terms that had produced, cumulatively, an income that I had not spent, because I did not spend money the way that people who are good at social rooms spend money. I had invested it, carefully, with the same methodical attention I brought to everything I did. By 2018, I had 31 patents and a licensing agreement with a biomedical device company that was, by any measure, significant. The application was a coding technology for implantable cardiac devices that solved a biocompatibility problem that had been limiting device longevity for 15 years. The licensing terms were structured on a royalty basis tied to production volume. The production volume, once the devices reached market in 2019, exceeded every projection I had modeled. I came home in the summer of 2019, and I told Marguerite what the quarterly royalty statement showed. She looked at the number. She said, "Is this real?" I said, "Yes." She said, "From one patent?" I said, "From one licensing agreement covering one patent application." "Yes." She looked at the number for a long time. Then she said something that I want to tell you precisely because it is the sentence that made me understand, with complete clarity, what the previous 21 years had actually been. She said, "Well, I suppose it was worth putting up with all of this after all." Putting up with all of this. I looked at my wife. I thought about 21 years. About every evening she had sighed when I came home late. About every party where she had introduced me with the particular faint apology of someone managing a liability. About every conversation where she had explained, patiently or impatiently depending on the day, that nobody at the table understood what I was talking about, and could I please just talk about something else? Putting up with all of this. I said, "Marguerite, I need to think about something." She said, "What?" I said, "Whether we want the same things." She looked at me with an expression I had not seen before. Or rather, I had seen it before, but had always interpreted it incorrectly. It was not the expression of a woman who was surprised. It was the expression of a woman recalculating. I was not yet sure what she was recalculating, but I was paying attention now in a way that I had not been paying attention before. And paying attention, in my experience, is where everything begins. The next 18 months were the months I need to describe carefully. Because something shifted, not all at once, gradually, in the way that things shift when a fundamental imbalance has been named, even obliquely, and both people know it has been named, and neither is entirely sure what to do about it. Marguerite became attentive in a new way. She was interested in my work in a way she had never been interested before. She asked questions. She attended an event at the university where I was being recognized, which she had not done in years, and she was charming and present, and made exactly the right impression, which she was always capable of doing when she chose to. She also, and I noticed this with the attention of a man who had spent 38 years in precise observation, began asking different questions about the financial structures, about how the patents were held, about what the licensing agreements provided for in the event of various contingencies, about what my estate looked like. I noticed. I am a scientist. I do not react to early data. I record it, and I watch for the pattern to confirm itself. In January of 2021, Marguerite told me she wanted a divorce. She said it at the kitchen table on a Sunday morning. She said it with the particular composure of someone who had made a decision before the conversation began. She said, "I have not been happy for a long time, Arthur. I think we both know this has not been working." I said, "I see." She said, "I want to make this as civil as possible. I think we can reach an agreement that is fair to both of us." I said, "What would fair look like to you, Marguerite?" She said, "The house. Half of the financial assets, and a percentage of the patent royalties going forward." The patent royalties. I said, "We should both get attorneys." She said, "Of course." I called my attorney that afternoon. His name is Gerald Marsh. He had been handling my intellectual property matters since 2006 and had expanded into general litigation when I had needed it on 2 prior occasions. He was 60 years old, methodical, and had the particular quality I valued most in any professional. He did not tell me what I wanted to hear. He told me what was accurate. I told him about the conversation. I told him what Marguerite had said she wanted. I told him about the royalties. Gerald was quiet for a moment. He said, "Arthur, the royalties are the center of this. How are the patents currently held?" I said, "In my name, all 41. He said, "And the licensing agreements?" I said, "Through an LLC I established in 2009, Pendleton Materials Research LLC." He said, "Who owns the LLC?" I said, "I do, entirely." He said, "Arthur, I need to ask you something and I need your honest answer." I said, "Always." He said, "Did Marguerite contribute to any of the research that produced the patents, in any documentable way?" I thought about 22 years. About Marguerite in the social rooms I could not navigate. About the parties and the introductions and the career that had run parallel to mine, without intersecting it in any technical sense. I said, "She did not." Gerald said, "Good. Then we have a position to work from. But Arthur, I want to tell you something. This is going to get complicated. When one party in a divorce discovers the magnitude of what the other party has, the initial offer of civil resolution has a way of becoming something else." I said, "How complicated?" He said, "That depends on her attorney." Her attorney was a man named Franklin Cross. I want to describe Franklin Cross accurately because accuracy matters. He was 53 years old. He had a very good reputation in high-asset divorce proceedings. He was expensive and he was aggressive, and he had, according to Gerald, a specific approach in cases where one spouse had intellectual property that the other spouse claimed to have supported through domestic and social contributions. The approach was simple. He would argue that Marguerite's role as the social and domestic anchor of the marriage had freed me to do my work, that without her management of our social life, our home, and our public presentation, I would not have had the stability to produce the research that produced the patents. That her contribution was not technical but was foundational, in a way that entitled her to a significant share of what that foundation had supported. It was, Gerald told me, a creative argument. It had worked in other cases. It depended entirely on the judge and on how thoroughly it could be substantiated. I said, "Can it be substantiated here?" Gerald said, "That is what we are going to spend the next several months determining." What followed was the period that tested my patience more than any research problem I have ever worked on. Depositions, document requests, financial disclosures. The particular machinery of high-asset divorce that grinds through everything a person has built and subjects it to examination by people whose job is to find the argument that serves their client, rather than the truth that serves the record. Marguerite's position, as articulated through Franklin Cross, was that she had been the foundational support of our marriage, and that the patents and royalties that had emerged from that marriage were marital assets in which she held a substantial interest. She was seeking the house, 40% of all financial assets, and 35% of royalty income from every patent granted during the marriage. 35% of royalty income, in perpetuity. I sat in Gerald's office after the initial filing and I looked at what Franklin Cross had put on paper, and I thought about the summer of 2019 and Marguerite looking at the royalty statement and saying, "I suppose it was worth putting up with all of this after all." I understood now what she had been recalculating at that kitchen table. I said, "Gerald, what is our position?" He said, "Our position is that the patents are your sole intellectual work, that the LLC structure separates the royalty income from marital assets in ways that are legally defensible, and that Marguerite's contributions, while real in social terms, do not constitute the kind of marital contribution that entitles her to intellectual property royalties." He said, "It is a strong position, but Arthur, I want to prepare you for something." I said, "Tell me." He said, "Franklin Cross is going to make this personal. When the legal argument is difficult, the human argument becomes the strategy. He is going to put Marguerite on the stand, and she is going to tell the story of 22 years of marriage to a man who was absent and difficult and incomprehensible to the people around him, and who she sustained through loyalty and sacrifice. And that story, in front of the right judge, can move the needle in ways that the legal position alone cannot predict." I said, "Let her tell it." Gerald looked at me. I said, "Let her tell every bit of it. Because I have been watching for 22 years, and I have my own account of what happened in this marriage. And it is documented." Gerald said, "What do you mean documented?" I said, "I mean that I am a scientist, Gerald. I record things. I have records of my work and my schedule and my output going back to 1986. I have the patent file for every one of 41 applications. I have records of the laboratory hours and the research notes and the conference presentations and the peer review correspondence. I have records of the licensing negotiations and the royalty structures and every financial decision I have made since we married." I said, "I have the record of who built what, and it is complete." Gerald sat back. He said, "Arthur, how complete?" I said, 38 years of complete. Now if you are still with me, and this story is hitting close to home, I want you to do one thing right now. Hit that like button. Because what happened in that courtroom on the morning of the hearing is something that required everything I just described to set up, and it is something I want you to see in full. Subscribe if you are not already here. Then stay with me. We are almost at the door. The hearing was scheduled for a Tuesday morning in April. I want to describe what I knew going into that hearing and what I did not know, because both things matter. What I knew was that Gerald had built a comprehensive legal response to Franklin Cross's filing. He had engaged a forensic economist who had assessed the patent portfolio and the royalty structures and had produced a report that Gerald described as among the most thorough he had seen in 30 years of practice. He had engaged an intellectual property specialist who had reviewed every patent application and had produced a second report establishing the sole intellectual authorship of each one. He had prepared testimony from 3 colleagues who had worked with me across different periods of my career, and who could speak to the nature of research work and the relationship between domestic support and scientific output. What I did not know was what Marguerite was going to say. Gerald had warned me. He had told me she was prepared to be comprehensive about her grievances, that Franklin Cross had spent considerable time preparing her testimony, that she was going to present the story of 22 years in a way that was designed to make me look small. I said, "Let her." He said, "Arthur, I need you to stay completely still when she speaks. Whatever she says, you do not react. You look at me, or you look at the judge, and you do not react." I said, "I understand." He said, "I mean it." I said, "Gerald, I spent 22 years not reacting to things Marguerite said. I have some practice." He almost smiled. He said, "Good, use it." We arrived at the courthouse at 8:15. I wore the suit I wore to patent presentations, which was the suit I wore to the things that mattered. Gerald had his briefcase and his notes, and the particular settled calm of a man who had prepared as thoroughly as preparation allows, and was ready for whatever the morning produced. Franklin Cross was already in the hallway when we arrived. He nodded at Gerald. He looked at me with the assessment of a man who had been building a case against me for 8 months and had formed a specific opinion about what I was. The hearing began at 9. The judge was a man named the Honorable Warren Chu. He was 61 years old, appointed to the federal bench 11 years prior, and had a reputation for patience and precision that Gerald had told me was exactly what we wanted. He had also, Gerald mentioned, an academic background before law. He had a master's degree in chemistry. I filed that information away. Franklin Cross made his opening statement. It was polished, and it was strategic, and it built the picture he had been building for 8 months. The absent husband, the incomprehensible work, The wife who had managed everything that mattered in the real world while he managed things in a world nobody else could see. He used the phrase invisible contribution several times. He used the phrase foundational support. He used the word sacrifice. He was good, I will give him that. Gerald made his response, precise, documented, structured. The IP specialist's report, the forensic economist's assessment, the colleague testimony. He was building the counterpicture with the methodical care of a man who understood that the truth, properly documented, could hold against a well-constructed narrative. Then Franklin Cross called Marguerite to the stand. She was composed. She was, as she had always been, exactly right in a room. She answered the early questions clearly and with the specific detail of someone who had prepared. She described the marriage accurately in its surface facts. The laboratory hours, the late evenings, the social occasions she had managed, the conferences I had attended, the introductions she had made on my behalf at events I could not navigate alone. She was not lying about any of those things. That was the difficult part. Every surface fact was accurate. The interpretation of those facts was where the distortion lived. And then Franklin Cross asked her a question that was designed to produce a specific answer, and Marguerite gave that answer with a conviction that I could see she genuinely felt. He said, "Mrs. Pendleton, in your own words, how would you describe your husband's professional standing and his impact on your life together?" And Marguerite looked at the court, at the gallery, at Franklin Cross. She did not look at me. She said, "Your Honor, this man is a worthless nobody who never amounted to anything. He spent 22 years in a basement while I built the life we actually lived. Everything real about our marriage was mine. He contributed nothing that anyone in the real world would recognize or care about." The courtroom went still. I looked at the judge. The judge looked at me. And in that moment, I saw it. The recognition I told you about. Because Judge Warren Chu, who had a master's degree in chemistry before he went to law school, was looking at the man across from him with the expression of someone who had just seen something that did not fit the description he had been given. He picked up his glasses from the bench. He put them down again. He looked at Franklin Cross. He said, "Counsel, do you know who this man is?" Franklin Cross said, "Your Honor, Mr. Pendleton is the respondent in this." Judge Chu said, "I am aware of his role in these proceedings, counsel. I am asking whether you are aware of who he is professionally." Franklin Cross looked at his laptop. He opened it. He began to type, and I watched his hands. His hands started shaking before he had finished reading. I want to pause here, because this is the moment. This is what everything before it was building toward. And I want to describe what happened in the next 11 minutes with the precision it deserves. Judge Chu said, "Counsel, I am going to take a 15-minute recess. I am going to ask you to use that time to complete your research. When we reconvene, I will have some questions." He left the bench. Franklin Cross closed his laptop. He looked at Marguerite. Something was happening on his face that I had not seen on the face of an attorney in a courtroom before. It was the expression of a man who has just discovered that the foundation of his case was built on an assessment that was not just wrong but spectacularly, documentably, publicly wrong. Marguerite said, quietly, "What is it?" Franklin Cross said, equally quietly, "We need to talk, right now." I sat at the table next to Gerald. Gerald leaned over and said, very quietly, "What just happened?" I said, "Judge Chu has a master's degree in chemistry." Gerald looked at me. I said, "He recognized my name." Gerald sat back. He said, "Arthur." I said, "Yes." He said, "Did you know he had a chemistry background?" I said, "You mentioned it when you described his academic history." I filed it. Gerald looked at me with an expression I had not seen from him before. It was not quite awe. It was the expression of a man who has been a lawyer for 30 years and has just watched something happen that he did not plan and could not have planned, and that was going to change the morning in a way that was now entirely out of Franklin Cross's control. He said, "What does he know?" Specifically, I said, "The biomedical coding patent, the one with the cardiac device application." It was published in a materials science journal in 2017, and it was the subject of a feature in a chemistry research digest in 2019 that had fairly wide distribution in academic circles. If Judge Chu reads that digest, and men with chemistry master's degrees who become federal judges often maintain connections to the field, he will know the patent and he will know my name. Gerald said, "And the 41 patents?" I said, "If he is searching right now, they are all public record. 41 granted patents, the licensing agreements that are part of the public record, the university research chair, the peer-reviewed publications, the conference keynotes. All of it is there for anyone who knows where to look." Gerald said, "Which an attorney preparing a case against you should have looked." I said, "Yes." He said, "Franklin Cross did not know any of this." I said, "Marguerite's description of me was apparently sufficient for his research." Gerald looked at Franklin Cross across the room, who was now in what appeared to be an extremely tense and extremely quiet conversation with Marguerite. Gerald said, "He built an entire case on the characterization of a spouse who called you a worthless nobody." I said, "He did." Gerald said, "And he did not independently verify what you had built." I said, "He did not." Gerald was quiet for a moment. Then he said, "Arthur, when we reconvene, let me do the talking." I said, "Of course. That is why I hired you." The recess lasted 22 minutes. When Judge Chu returned to the bench, he had a yellow legal pad in front of him, with what appeared to be several pages of notes. He settled into his chair. He looked at Franklin Cross. He said, "Counsel, have you had an opportunity to complete your research?" Franklin Cross said, "Yes, Your Honor." He said, "And?" Franklin Cross was quiet for a moment, that lasted longer than a courtroom moment should last. He said, "Your Honor, I want to request a brief continuance to allow the respondent's team and my client's team to revisit the evidentiary basis of the petitioner's claims." Judge Chu said, "I imagine you do. Request denied." He put his pen down. He said, "Mr. Cross, I have been on this bench for 11 years. In that time, I have presided over asset disputes involving business owners, executives, artists, and professionals of many kinds. I want to be precise about something this morning." He said, "The characterization offered by your client of the respondent as a worthless nobody who never amounted to anything is inconsistent with a public record that includes 41 granted patents, 3 active licensing agreements that have produced royalty income in excess of what this court sees in most years of asset cases combined, a named research chair at a major university, 46 peer-reviewed publications, and a specific patent application in biomedical device coatings that has been cited in the medical literature as a significant advance in cardiac implant technology." He paused. He said, "I am familiar with that application, Mr. Cross. I read the journal in which it was published. I have in fact used that journal as a reference in my own understanding of materials science since my graduate work in chemistry decades ago." The courtroom was completely still. He said, "I am not suggesting that the petitioner's claims have no merit. That is what these proceedings are for. What I am suggesting is that the evidentiary foundation of those claims, and specifically the characterization of the respondent's professional standing and contributions, requires significant recalibration, and I am going to strongly recommend that both parties avail themselves of the full public record of Mr. Pendleton's professional output before we proceed further." He looked at Marguerite. He said, "Mrs. Pendleton, I want to give you the opportunity to reconsider any testimony you have given this morning in light of the complete professional record of the respondent. You have that right." Marguerite's face did something I had not seen it do in 22 years of knowing her. Every composure she owned left it at once. Not in anger, in the specific expression of a person who has built an argument on a foundation and has just been shown, publicly and precisely, that the foundation was not what they believed it to be. She looked at Franklin Cross. He did not look back. She looked at me for the first time that morning. I looked at her, and I thought about the kitchen table in 2019, about the royalty statement, about putting up with all of this. I did not say anything. I looked at her until she looked away. What happened over the following 3 weeks, I want to describe accurately, because the resolution matters as much as the moment. Franklin Cross requested and received a 2-week continuance. In that 2 weeks, the reconstituted picture of my professional record, the 41 patents, the research chair, the publications, the licensing agreements, the royalty structures, the accumulated asset value of what the LLC held, produced a fundamental restructuring of Marguerite's legal position. The claim on patent royalties in perpetuity was withdrawn. Gerald had always believed it was legally unsustainable, and the forensic economist's report had established that clearly. What the continuance produced was the recognition, on Franklin Cross's part, that the argument he had built around Marguerite's foundational support of an apparently ordinary man was an argument that could not survive the actual record of what the man had built. The settlement, which was reached in the 3rd week, gave Marguerite the house. She had chosen it with me. She had lived in it for 16 years. It was hers in the way that a thing becomes yours when you have arranged your life around it for that long. She received an equitable share of the jointly held financial assets accumulated during the marriage. Gerald fought for precision on the definition of jointly held, and the precision mattered. She received nothing from the patent portfolio, the LLC, or the royalty agreements. The intellectual property had been built by one mind over 38 years, and the record of that building was too complete and too documented to admit any other conclusion. I moved into a rental property while the house transferred. I sat in it on the first evening with a cup of coffee and a notebook, and I thought about what had been settled and what had not. Some things do not settle. Not in weeks, not in months. What settles eventually is not the anger or the grief or the particular specific hurt of having been called a worthless nobody in open court by the person who was supposed to know you better than anyone. What settles is the understanding, the slow, imperfect, incomplete understanding of how two people can spend 22 years in the same house and construct entirely different pictures of what was happening in it. Marguerite had not been lying about what she saw. She had been limited by what she could see. She understood the world through the lens of social visibility and external validation, and I, in my laboratory and my research, and my 41 problems solved and documented and granted and licensed, was almost entirely invisible to that lens. She had looked at me and seen nothing. That was not cruelty. It was a failure of sight, a failure I had contributed to by never finding the language to make what I was doing legible to the person living closest to it. I thought about that. I thought about it for a long time. And then I opened my notebook and I started working on problem 42. I want to speak to you directly before I finish this story. If you have ever built something that the people closest to you could not see, I want you to know something. The invisibility is not evidence that the thing is not real. It is evidence of the distance between different kinds of understanding. The work was real. The 41 patents are real. The cardiac device coding that has extended the functional life of implantable devices in patients who would otherwise have needed revision surgery is real. The peer-reviewed publications, and the research chair, and the conference keynotes, and the graduate students who went on to their own work are all real. None of it required Marguerite to see it to be real. What required Marguerite to see it was a courtroom, and a judge with a chemistry background, and a morning when the gap between the story she had been telling about me and the record of what I had actually done became visible to everyone in the room at the same time. That was not revenge. I want to be clear about that. I took no pleasure in her face when Judge Chu read the patent list. I took no pleasure in Franklin Cross's shaking hands. Those moments were not victories. They were corrections. The correction of a record that had been wrong for a long time. The revenge, if there is a word for it, was the 41 patents themselves, the 38 years of work, the problems solved and documented and contributed to fields that matter. The revenge was living the life I was supposed to live, regardless of whether the person across the kitchen table could see what it was worth. That is the only revenge that lasts. Share this video right now if it meant something to you. Hit that like button and subscribe, and leave me a comment below. Tell me about something you built that the people closest to you couldn't see. I read every one. I will see you in the next story.